Hi, I'm Attorney Tom Lamb in North Carolina. In this Asbestos News Minute, I want to tell you about a July 2009 jury verdict in California in favor of the family of a worker who died from his mesothelioma. The jury awarded $3.4 million, but for reasons that will be explained during this piece, the family will likely only see approximately $800,000 from the one defendant that went to trial, Advocate Minds of Canada. There are prior settlements in this case reportedly to the total amount of about $1.5 million. If you add that to the anticipated $800,000, the family will realize about $2.3 million. But this barely touches the loss to the family, no doubt, losing Mr. Richard Worthley Sr. to mesothelioma. The jury in San Francisco deliberated just one day before deciding that this Canadian mining company, Advocate Mines, was liable to Mr. Worthley, who was a former Johns Manville Transite plant worker. He worked in Waukegan, Illinois, at the Johns Manville plant there that made the Transite asbestos cement pipe. And Mr. Worthley was employed from May 1968 to 1984 when the plant closed. He was diagnosed with his mesothelioma in 2004. As many of you know, mesothelioma is caused by exposure to asbestos, and it is a fatal and tragic cancer that typical lifespan following diagnosis is 6 months to 18 months. Mr. Worthley held several jobs at the Johns Manville plant. He was a painter, a production planner, and a millwright, and in those capacities was exposed to asbestos dust, including the raw asbestos fiber that was supplied to the plant by Advocate Mines of Newfoundland, Canada. The two main issues during the 6-week trial were, number one, whether Mr. Worthley was exposed to asbestos dust at the plant, and number two, whether the asbestos from Advocate Mines played a role in causing his mesothelioma. A secondary defense argument was that the form of asbestos that Advocate Mines had supplied to the mine, chrysotile, was not as dangerous or hazardous as other forms of asbestos. That argument failed. Plaintiffs' experts testified that the scientific literature and U.S. safety standards are all very consistent in stating that all types of asbestos fibers, including chrysotile, cause mesothelioma. Chrysotile is another type of asbestos fiber, as is tremolite. But again, the chrysotile defense is oftentimes raised by defendants in mesothelioma trials, and here the jury wisely rejected that defense. In fact, during cross-examination, the attorney for the plaintiffs confronted defense experts with articles by 52 mainstream scientists confirming that chrysotile asbestos fibers cause mesothelioma just as chrysotile and tremolite asbestos fibers do. On July 22, 2009, the 12 jurors unanimously held that Advocate Mines was liable for negligence, defective design, and failure to warn. They awarded $877,000 in economic damages and $2.5 million in non-economic damages. And there's going to be some significance in economic damages as opposed to non-economic damages, as we'll see in just a moment. The jury assessed Advocate Mines with 5% liability. They did not assign the other 95% of liability to any other defendant. Advocate Mines was alone at the trial. As I mentioned earlier, some defendants had settled prior to trial and therefore were not present at trial. Now, under California law, Advocate Mines is jointly and severally liable for the economic damages, but only liable for its 5% share, that is its share of fault, for the non-economic damages. So, when the judge applied the 5% at fault determination to the $2.5 million in non-economic damages. That meant that Advocate Mines was liable for $125,000 of that $2.5 million amount. Turning to the economic damages, going forward, and this will take place in mid-September, the judge will consider the economic damages awarded at trial, the settlements from other defendants, and Advocate Mines' liability in calculating a figure with regard to economic damages to add to that $125,000. Current speculation is that the economic damages will range, will result in a total award to the family in the range of $750,000 to $800,000. Now again, remember they had $1.5 million in other settlements, so we add that up, and at the best case scenario, it seems the family will realize $2.3 million out of this asbestos case. But losing a family member to mesothelioma, even that amount of money is not going to make things whole, so to speak. Another tragic victim to asbestos exposure and a painful death by mesothelioma. For more information, visit asbestoslegalwatch.com. Thank you, and have a